All right, ladies and gentlemen, I don't think we're probably going to get too many more. How are we all tonight?
Good, thanks, Brian.
Excellent. Well, before I start, I suppose, so you have an understanding of who you're talking to, by way of introduction, I'm Jack. I'm 23. I'm currently living in Brisbane. Been studying I've done about 7 units so far, and just picked up constitutional law as well as torts B this semester. For work, I currently work for the Department of Defence. I'm in the Army as an intelligence analyst. And so a lot of my experience and strengths quite heavily lie in research and interviewing and debriefing, which hopefully will one day come in handy. So I posted to the forums earlier today my intent for the running of this half an hour session, and I'll just quickly go over it again for those who missed the opportunity to read that. So initially, my intent was to discuss the assignment, the group assignment amongst ourselves, beginning with Manjo's guidance of discussing what we as individuals or groups believe the legal issues to be. Secondly, any form of independent analysis that you may have done already or may not, which is fine, as well as moving on to then the remedies, perhaps, and then the conclusion. And then secondly, I posted again a topic which, for even just a bit of funsies for us to work through to have a learned discussion about. If you had a chance to read it, sort of indicate in the chat. Okay, so, well, first of all, we can begin with. It's all right. I'll post it in the chat. It can be a legal technical term. So let's have a look. Sorry, just excuse me for 1 second. Where did I put it? All right, so I'll find it while we start. I'm not 1 area. I used to be 3 area, but so first of all, we'll begin with the group assignment. So beginning on question 1. Question 1 being, the Australian has reported recently that the Australian Security Intelligence Organisation, ASIO, Australia's largest security agency, has been eavesdropping on mobile, landline phone calls and intercepting work with personal emails within Australia as part of its efforts to deal with terrorism and politically motivated violence. When the ASIO Director General of Security was asked about ASIO's draconian actions, which appeared to have exceeded the statutory grant of power under the ASIO Act 1979, he defended his agency's actions with being authorised by the broad powers of the executive. So Mr. Dick Rayner has come to us, a solicitor for legal advice about the legality of ASIO's action. So the question that was posed to us as students, this is the group 1 again, is what advice would you give him? Again, the guidance that's been given to us is that the answer should be limited to topics covered between 1 to 5, noting that we're not to address the issues about Commonwealth powers relating to defence and external affairs, nor the constitutional rights and freedoms. So you don't need to read into the ASIO Act and assume that, we are to assume that the ASIO's actions are beyond the statutory grant of power. So who would like to kick us off with the first sort of identification of a legal issue that you can see under this topic? Anyone?
Hear me?
I hear you loud and clear.
Sorry, sometimes I have to press the button, sometimes I don't. So first sort of discussion point or issue that came to mind was looking at or evaluating the principle of legality. and how, in exceeding its powers granted by the Act, ASIO may have departed from the principle of legality?
Yep. Now that sounds about what I assume most people have sort of identified. Is that an agreed across the board? Just a nod will do. Excellent. So that's a good point, Monique. So in identifying the legality, where should we begin to look for the identifying the exact left and right of the legality of this issue? Any suggestions from anyone? No. Of course, the Constitution. It is an unwieldy beast, isn't it? But so excellent. So have we? Has anybody been able to identify any common law precedents in regards to something very similar? So Kathleen, you had some input on that?
Sorry, the issue I was going to raise was the prerogative of the autonomy of the individual.
Yep. And you just like to walk us through in 100 words or so your understanding of that? Because I personally haven't come across that one.
Aren't the prerogatives in relation to sort of unwritten powers of the executive rather than the individual?
That's a good point. My understanding was that the prerogative powers were to the individual of under the guise that you are free to do anything that is pretty much not outlawed. Is that? I assume from looking at some puzzled looks that I was incorrect in my understanding.
No, I agree. It's in regards to conventions and prerogatives. It's not just about the executive powers. That was my understanding anyway. It's about what the Constitution stipulates as everyone's rights and obligations and powers within the Parliament, but as well as that, what's left that they shouldn't be touching in regards to overstepping their boundaries.
Excellent. Did anybody have a retort or a different understanding? No, everyone seems to be on board with that. No worries. So, was anybody else moving on to that? Was anybody else identifying any further legal issues that they may have come across in this particular topic, being topic 1?
The only thing I also thought of just in rebuttal of the the assumption or the understanding that ASIO was stepping outside the boundaries was whether or not there was any other charters of powers such as emergency, like terrorism or politically motivated violence, that they could use as a defence. for the reason why they would be doing that.
Okay, so as in if there'd been any further legislative powers that have been granted to them outside of, and then them using those as the precedents, for example, an example being the use of Counterterrorism Task Force East in the event of domestic security situations.
More like the Constitution leaving, you know, the ability to grant emergency powers, whether or not they would use that as a defence in regards to, well, it could be a situation where they were concerned about terrorism. Not that, you know, obviously anything has been said about, you know, saying it's a state of emergency or anything like that, but I'm just thinking more along the lines of the possible defences to the action.
Okay. Yeah, that it definitely sounds. This definitely sounds clear and sounds correct on the sort of first glance. I'd have to look into that one even a bit more. Just having a look at what else, because we're very conscious of the time this evening.
I'm also just not sure that we've covered, like, I mean, we've definitely covered all the stuff we need. Well, in my opinion, we've covered what we need for question 2, but I just don't know whether we've actually in class yet covered all of the stuff that we would be looking into for question 1 to be answered entirely. So we may be needing to stay tuned. There might be more information to come yet.
Yeah, considering the question, the topic, it's the question still has another 2 weeks of topics to cover in order to truly answer the question. It was just the opportunity to pinpoint people's thoughts about the upcoming assignments, which I suppose is really the purpose of these. So if everyone's happy to move on to question 2. Or has anybody got anything further to add for question 1?
Sorry to bring it up again, but I just would like, because a couple of you have mentioned about prerogative power and the individual. I just wanted your, I guess, take on that again, if you could put it in different words or expand on it a bit. For some reason, I'm stuck in my head that prerogative power is like relatable to discretionary powers that the Commonwealth has, and therefore I just can't see the link to the individual. So if anyone can, sorry, Gay, you talking? Oh, yeah. So if anyone can expand on that for me, see where perhaps I've missed a point somewhere, that'd be great.
I think you're actually looking at it from the right perspective, but maybe just spin it around a little bit in that, yes, it is, in my opinion, it's about the, you know, limitations on the powers or the stipulation of the powers of the executive. But it's also about stipulating what they can't, what they shouldn't be making legislation about, or what they shouldn't be overstepping the boundaries on. So if they're overstepping the boundaries when it comes to the autonomy of the individual, then the prerogative is that they're overstepping those boundaries. And the case that's in the textbook on this is the one that you've probably heard from Torts A, if you did Torts A lately or remember it. And it was the one where the judge, and I can't remember the name of the case, but the judge actually stated about, you know, you can't bruise the grass or step 1 foot onto, you know, someone else's property. And I don't know the exact words, but those were the words used. And it's in the very beginning, probably the first week of reading we did in the textbook. But because I haven't prepared it or anything, because I just know it's in there, but maybe I could have a look again later. But that was the example used was not overstepping that boundary and not, bruising the grass of the person or whatever, of their property, because that's their autonomy, that's their legal right. Anyway, that's my understanding.
And sorry, just to add, there's actually quite a good and very good explanation on it on prerogative powers, funnily enough, from the Australian Parliament's actual website, and they provide quite a good definition along with some links to some key cases about prerogative powers. So I can post that link in the chat if everybody would like that. Yep. That one. And now, so I've come across the Australian Parliament's actual website to have be quite a good sort of ready reckoner for certain issues of. Oops, sorry, people are talking at me. Yep, there we go. Sorry. So the. Okay. Yeah. Nasir, would you mind muting your microphone, please? Okay. So if we're all happy to move along to the second part. So question 2 is that states that Juliet Sanders has lost her government-funded family tax benefit and childcare benefit after she refused to have her 2-year-old daughter vaccinated. Under tough new rules on children whose parents chose not to vaccinate them, the federal government passed legislation that required parents to meet immunisation requirements in order for them to receive or continue to receive the family tax benefit and childcare benefit. So Sanders has come to us again as solicitor for legal advice. He is considering court action to the question of the validity of the subject legislation. What advice would we give her? Would anybody like to lead us off on this one?
I don't know if I'm right on this one, but does this come back potentially to the political issue versus legal issue that Manjo touched on? I think it was in the drop-in session on Monday.
Sorry, you'll have to excuse me. I didn't actually go to the, I wasn't actually at the drop-in session, so I'm unable to answer that.
That's okay. I only watched it online myself today. Manjo touched on, I think it was in that session, but it was about how you have a legal issue versus a political issue and whether the courts will come in and intervene on such matters.
Yeah, I think that's what this relates to. That's how I understand it.
So does that then perhaps encroach on the court's ability to rectify laws that have been passed that may be seen as unconstitutional? Because one could see that the decision to remove whatever your stance on the political of vaccination, however it may be unconstitutional, perhaps be seen, removing the person's freedom of choice may perhaps be an issue.
Yeah, I think in regards to that, I was looking at that as a bit of a defence. But when Manjo had that session, he made it pretty clear that the only determinant the only positioning that the judiciary would be looking for would be whether or not it's a legislation passed by the representative government. And, given that the principle of the representative government is essentially meaning that the government is a representative of the people. So therefore, if a legislation gets passed by both the lower and the Senate, this legislation would be a representation of what the people had elected. So therefore, it wasn't a a question of law or legality, therefore wasn't, constitutionally invalid. So therefore, given that it's not a question of legality, the judiciary does not have, any say in the particular law, because it's been passed as a representation of the people, in the principle of the representative government. And given that the judiciary cannot overstep their boundaries in regards to separation of powers, the only way that it could be seen as part of the judiciary's concern is if there was anything in the separation of powers that suggested that there had been a breach, and that would be if the government had consulted a member of the judiciary before passing it, or they had in some way played a part in the legislation, which is obviously not the facts of the case.
That sounds quite a lot better worded than my understanding. That's definitely cleared up a lot of the understanding in my mind of that. What's people writing? Yeah, that definitely makes a lot more sense than sort of what I was thinking, which is always good. Did anybody have anything else to add for question 2?
The only further thing I had was in regards to, constitutional rights and freedoms being violated, that the law doesn't actually stop a parent from making medical choices about their child. It actually just stops them from receiving, a payment in regards to that. So their choice is not actually being taken from them, even though you might not agree, because some people might need that payment or whatever. But essentially, when I was looking for defences when it came to this, and I know a lot of people, when Manjo was raising it, was sort of a bit like, but that doesn't seem fair that they can make these laws and the judiciary doesn't have any, people can't appeal them through the courts. But I just, the only way I could sort of come to grips with it was the fact that it's not actually stopping the parent from making the choice. It's just stopping them from getting the payment. But essentially Manjo didn't really have, it was just that's how it works, unless that they sort of go, next time you go to an election, you elect someone else. That's essentially all that can happen.
Okay, that's again, that's a very well explained argument. That it's just really well put. Thank you very much for the input. So if nobody had anything sort of further to add for question 2, we could perhaps move on to question 1 for the individual midterm assignments, if everyone is happy with that. Or if anyone has anything else they would like to talk about in regards to the group assignment, speak now or forever hold your peace.
I've just got a, sorry. I've just got a quick question. In terms of forming groups, I had one person that I was partnered up with, and we sort of said to Manjo, look, can you put us in a group? Has anyone found or seen a link where that's been finalised?
I haven't. I personally haven't, because I managed to squeeze myself into a group of 4 early. But it might be on the partner finding forum.
Yeah, no worries. Thanks.
Someone's. Sorry, Kathleen.
Sorry. Oh, sorry.
You go, Gay.
I just wanted to say on that too that I was a bit worried that maybe people are going to disappear before census date, because we had a group of 4, but I've found one person, but the other 2 people I haven't seen pop up anywhere, and I've sent them emails and all that sort of stuff. So I know that he's already said group dynamics is no excuse, but if they're dead or left the course. So if you're out there, if you can hear me, blink or send me a letter or something.
Right. Well, hopefully they're not dead. Hopefully they're still ready to go. Okay, so we're all fairly comfortable so far with the perhaps somewhat limited reading into the problems we've done so far. Everyone seems fairly comfortable with the concept of the first assignment. I'm not too sure how much we're going to get into the second part of the individual assignment, but we'll get through as much as we can, noting we've only got about 5 minutes left. Or we could use the next 5 minutes to just any further discussions about any problems anyone's had in the course so far, that maybe someone else would be able to give them some insight or even a different perspective on something. If so, sort of a go for a group decision on which way to run that one. Any reason we can't? Sorry, yeah. Look, I would love to. I've actually got some stuff I've got to do. Like you guys could stay, I presume, but I'd be unable to facilitate overtime. Yep, sure. Okay, so the first question being question 1. Roman Quadson, a top executive of the federal government agency, was dismissed from service after an investigation and internal disciplinary hearing determined that he had engaged in an inappropriate relationship with a female staff member. Responding to the newspaper reporter's questions about his dismissal, Quadson said, "I'm the victim of scandal mongers who want my job, and I now look forward to exonerating myself from the Oh, yep. Take it. Everyone's read it, I assume? Cool. So, determining our question that he needs to know that whether his dismissal, the legality of his dismissal, asserts that the engaging in the appropriate relationship is factually incorrect, and seeking the advice. So we've got some people leaving. Okay, cool. So who'd like to kick us off for this one? In the limited time we have. I'm just reading. Ooh, so did anyone?
It's Monique. So I've kind of drafted an answer, but I really don't know if I'm on the right track or not. So I really appreciate some thoughts from others. I couldn't really identify the legal issue, I guess, other than his concern that the decision was made on the basis of an incorrect finding of facts. And so through my research and, identifying a few different acts and laws that he, as an APS employee, needs to comply with, I kind of came to the conclusion that he can challenge the legality of the decision on the basis of an incorrect finding of facts and seek a review per the Administrative Decisions Judicial Review Act. And that's kind of where I came to, but I didn't really know if I had to identify that or what. Does anyone have any thoughts?
My thoughts on it were probably a bit more, I guess, a bit less detailed. It was more I was thinking the legal issue was more about whether he can challenge before the court, and how, like what the court's permitted to actually do there, rather than the nitty-gritty of whether the facts are saying that whether the facts are incorrect or not. Wasn't really thinking that would be getting down to that level. I was more thinking it was about whether he can actually make that challenge to the court. I was just presuming that the facts were incorrect.
I think it's pretty clear in saying that he's already gone through the internal measures that he can do to appeal that. And I think that, yeah, Monique, that the next step would definitely be an appeals tribunal, because that's obviously, the next stage in appealing that. So I think, though, that you would have to provide, like I think you would have to provide some sort of, write-up as to what he would be appealing and what the grounds are. So I think you would have to sort of go a little bit into how he would lodge that appeal or what he would say.
I've hit the 500 words already, and have gone into that sort of thing. I guess why I questioned my approach is that I haven't particularly addressed any of the constitutional law principles that we've been reading about. I mean, I've referred to other acts and the process that he needs to follow, but yeah, does that make sense? I'm just not sort of hitting any specific principles that we've gone over in the material.
Yeah,
and I've read all the weeks, so I couldn't.
I think we've only very briefly sort of discussed, or like in the readings and that read about the appeals tribunal, like not even briefly. It's just like a mention. So again, what like I said, I'm just assuming that that's the next step along the line of what needs to be done, because it's not it's not a matter for the High Court. Obviously, it's an appeals tribunal because it is a matter about a federal government agency. But in saying that, that doesn't mean that if Roman feels he doesn't get adequate recompense in that sort of place, that he couldn't then go further in regards to employment law to High Court. But I just think it's appeals tribunal. But I don't know.
I think you might be right there, Kathleen, on that he does need to go to the appeals tribunal, but I think like we're getting into too much detail of what he actually needs to do. Like the base of the question is that he wants to know if he can challenge before the federal court. I don't think he wants all the detail of, or I personally wouldn't put all the detail of how he'd go about appealing and what he needs to do or that kind of thing. I'd be more looking at doing an IRAC on whether he can actually challenge before the federal court and what they can do, not so much, okay, no, you can't do that, you need to go off and do this, this and this. I'd be more focusing on just what the federal court can do, especially with our word limit. What other thoughts on that are?
Can I just butt in there that the Administrative Decisions Judicial Review Act provides that you can apply to the federal court for an order of review, as far as I can see from my research. Yep. So, it does kind of give that answer as well.
Yeah, so I would be going into, like you said, that he is allowed to do that, so I'd be going into, well, the rules are he can do that, and the advice would be this is how he does that, rather than too much detail into how he would appeal or that kind of thing. I think it's more about just that base thing that he can actually appeal to them, if you know what I mean. Like, I think that's the constitutional issue. Can the federal court review that? Do you know what I mean? Like, I'm probably not explaining it very well, but
yeah, no, that's obviously, if you have a read of the actual question, that's the stuff that you would be underlining as the key question being asked. So I think I'm a bit on board with Monique though in saying that I don't know where we've read that. So I don't know where that information's coming from in those 5 weeks. But anyway, I'm sure research is part of it.
I guess it's about the powers of the court to challenge, or the powers of the court to review decisions, and perhaps that's where, you know, it comes into play, and the role of the court in conducting those reviews. And that's really the only link that I could make.
All right. Well, sorry guys, that's a great conversation. It's terrible to cut it off there, but that's time for us this evening. Unfortunately, I'm unable to stick around any longer. You guys feel free to sort of stick around if you can. However, that's the end of the my sort of, let's call it, directed way we'd run this tonight. I'd like to again say thank you for everyone to coming, and thank you for your patience as we stumbled our way through this today. It's the first one there is, and hopefully they should just get even better each week. Thank you very much again, and enjoy your evenings. Sorry, Manjo's the host, so I guess you can stick around until Manjo comes and kicks everyone out at the end of the night. All right, everyone, have a good evening.
Thanks, Jack.
I want to discuss question 2. Go first.
I think, isn't this the same thing that we discussed the other night?
So, yeah. So, Manjo raised the issue of Boilermakers and that it doesn't apply in the States. And my question was, what about the principles raised in Cable that suggest that the state courts are part of an integrated federal system? So I'm still, I'm not 100% clear on that relationship. And I'm also a little bit concerned that I have talked about Boilermakers briefly when Manjo said that it does not apply in the States. So does anybody have any thoughts on the two issues? And perhaps, Boilermakers does need to be disregarded altogether and only Cable is relevant, and other things, obviously. But yeah, I'd be interested. Sorry, I keep muting myself. Others' thoughts?
Would you still have to, though, talk about Boilermakers to discount it?
Yeah, I think so. I think the issue is that I've sort of also talked about the vesting of non-judicial power in Chapter 3 courts, but maybe it's not relevant. I do think, it deserves a slight mention. You're right.
Because I think only from what Manjo was saying, I haven't had a chance to really get into the individual ones yet. But just when he was talking about the fact that you could vest non-judicial powers on judiciary in state, in theory, but the High Court won't tolerate it. So, I would just assume that you need to be raising those sorts of issues, but then it would sort of make it a bit of a 500 words on what not to do, not what to do.
Yeah. The other thing I considered was the persona designata rule. So looking at, and see, that particular rule is an exception to the principles in Boilermakers. So again, referencing Boilermakers, but whether or not it applies, and I'm going then around in circles. I mean, I've put together a bit of an answer and I'm quite happy with it, but I'd really, really like, you know, to hear how others feel about that. So did persona designata come up for anybody else as a potential issue?
Not really, because I think it, I sort of discounted that for more of a discussion about the level of state powers and, you know, essentially the limits on the state powers and what you could vest. So I think in using all the words up, I certainly wouldn't have any room for a discussion on that. And I suppose I just took it when Manjo said to be disregarding Boilermakers as to not feeding into other possible, you know, things brought up by that. But essentially, you're still going to have to mention Boilermakers. So then that poses the question of, do you have to go into Boilermakers that much to talk about other possible defences?
It's been a tricky one. Like I said, I've been going around in a few little circles trying to avoid Boilermakers, and then it pops in there and then I'm trying to get rid of it, and you know.
I think just talking like the main parts that I was trying to concentrate on were the two restrictions he said, that there always, you know, while there always has to be a state court, and the mere instruments or tools either of the state parliament or executive. And that's what I was sort of trying to concentrate mainly on.
So by giving that power to the judges to advise, legally advise the police, that would be like repugnant to that idea. Is that what you're getting at?
Yeah, definitely.
If at least one person thinks a little bit of what I've written, you know, the thoughts that I'm thinking, then I feel like I'm okay. You know, I'm questioning myself a lot, and I think we all do. So it's nice to discuss it and just hear that it's not completely off track. I know we're not giving answers, but just having that discussion with other people is really helpful.
Yeah, I think so too, because I always have difficulty actually handing the paper in, because I just want to redo it 100 times and you've got to stop at some stage. So I think these sessions will be good, especially as we get closer to actually having to hand it in.
Thanks, guys. Is Manjo there to shut the chat down, or we just jump out? And I didn't catch what he said at the start.
Oh, you got it up to